Counsel. I'll go ahead and get started. My name is A.J. Singleton. I want to welcome you to the next installment, if you will, of the SKO U CLE series that we started last year. I believe that this is the fourth in the series, and we've got another one already scheduled coming up for February 24th. Amelia Adams here in our SKO Lexington office will be discussing bankruptcy, and I'll have a slide at the end of the presentation to give you more information on that. But again, my name is A.J. Singleton. We're here to talk today about legal ethics for the in-house counsel. A couple of housekeeping matters before we get started. First of all, as I mentioned just a second ago, as you're logging on, if your device is not already muted, please do so. Also, at the end of the presentation or sometime this afternoon, I will be emailing each of you both a survey for you to fill out, if you would, so that we can get your feedback and get some ideas about, for example, possible future topics you would like SKO to discuss in these seminars. But also, very importantly, that email is going to contain the activity codes that you're going to need for CLE credits, both in Kentucky and Indiana. This program has been approved by both Kentucky and Indiana for not only 1 hour of CLE credits generally, but also that all important 1 hour of ethics CLE credit for both jurisdictions. If you are licensed in another state and would like credit applied for that state, please just respond to that email that you receive, and we'll see what we can do to get credits for you in that jurisdiction. With this being a quote-unquote live presentation, albeit over the internet, Indiana in particular has some attendance requirements, but also that applies to Kentucky as well. And so for that purpose, during this presentation, you see Renee Lamb's icon there. She's in our marketing department. She has volunteered to assist me with this. Please privately message her with your full name, first and last name, what state you're licensed in, and the bar number for that particular state. That's one of the things that we have to do, is collect that information from you to attest to the fact that you were actually here and participating. Lastly, as sort of an introduction or housekeeping, we are recording this. We are starting to put these videos soon on our YouTube channel, the SKO YouTube channel. It is not yet live, but we intend to put this presentation and others on there as well. For that reason, we are going to not have a Q&A session during the presentation, but after the conclusion of the presentation, I will stay on the line, and if any of you in the audience have particular questions that you would be interested in discussing and posing for whoever in the group might remain, that'd be an opportunity for you to do so, and that would not be recorded. So with that as background, let's go ahead and get talking about legal ethics for in-house counsel. And let me start by giving a little bit about my own background. By trade, I am a SKO litigator. I used to do a lot of fiduciary duty litigation, trust and estates litigation, worked on some derivative action cases, and more recently have worked on law firm breakups. But that's only one of the two hats that I wear. And probably the hat that I wear most often, and certainly over the last several years, is that I am the firm's general counsel. So in that sense, I have I've got one foot in the outside counsel realm, and like many of you in the audience, I've got a firm firmly placed in the in-house counsel realm. Just as each of you who are in-house counsel have your organization as your primary client, I too have SKO as my primary client. So I have a little bit of sense of some of the difficulties that each of you might sense in terms of how the rules of professional conduct equate to your world. You know, the rules of professional conduct, just as this quote from Nicole Hyland recognizes, the rules of professional conduct were not designed with y'all, in-house counsel, in mind. They were largely drafted starting in the 1970s. They haven't evolved much since then. The rules of professional conduct are really driven by applying mostly to litigators. I know that transactional attorneys sometimes have difficulty seeing how the rules of professional conduct apply to them. For you guys as in-house counsel, it's even more difficult to apply the rules. And yet we know that the rules of professional conduct apply to you. I mean, for example, in Rule 1.0, the terminology or definitions part of the ABA model rules, part of the definition of firm is not only a law firm, but it specifically includes legal departments of organizations or entities. So we know that the rules are to apply to you guys, but just as Nicole Hyland points out, it's difficult to find programs and such that are designed to help you guys navigate through some of these ethical dilemmas and the rules of professional conduct that you might find yourself in. So part of this presentation is really designed to maybe act as a gap filler for you in-house counsel out there, to look at some of the rules, some of the issues that you might face on a daily basis and be able to see how the rules might apply. The topics for today's presentation I have pulled from other presentations that I've given to various other in-house counsel, and the types of things that I think that in-house counsel should hear about, and the types of things that other in-house counsel have posed to me, saying, what do you think about this? Those topics are, who is your client? Avoiding inadvertent creation of attorney-client relationships. Privilege in the context of being an in-house counsel. Looking at the no contact rule, Rule 4.2, about communicating with persons represented by counsel. And then finally looking at Rule 1.6 and certain technology changes that have occurred in that rule, and actually how that might apply to your role as in-house counsel. You know, when I'm going into presentations like this, part of my job is to make sure that you in the audience are sensitized to some of these issues. That might not present all the answers, but at least it will allow you to identify the issues and potentially know where to go to find your answer. Two more sort of overriding themes that you're going to see in this presentation is that it's important for you as the in-house counsel to work with the non-lawyer constituents within your organization to educate them on some of these issues. For example, we're going to be talking about the in-house counsel attorney-client privilege. It's important for you to educate your colleagues who are not lawyers on what the privilege means, and maybe more importantly, how it can be waived so that there's not an inadvertent waiver of the privilege. The other thing that's going to be an overriding thing is communication. I see with a lot of the ABA ethics opinions that are coming out that there's a great renewed focus on communication. And that's on your end, communicating again with those non-lawyer constituents that you deal with, but also making sure that you understand that your outside counsel has a duty to communicate with you about some of these issues. And so you yourself can reach out to outside counsel so that you can have a dialogue on things like what type of security measures should we have in place when dealing with these more sensitive litigation matters, things of that sort. So let's start with the topic of who is your client. This is quite possibly one of the most fundamental questions or issues of legal ethics, because there's so much that is connected to an attorney-client relationship. If you think about it, it is the client to whom your duty of loyalty and your duty of confidentiality goes to. So it's important for you to know and for you to appreciate who your client is. Now, as an in-house counsel, and this is going to be almost seemingly a no-brainer, there is a specific rule that says, look, if you are employed or retained by an organization to represent the organization, it is the organization who is your client. And your actions or your instructions that you receive are through the authorized constituents. However, pursuant to this entity rule, Rule 1.13, it is important for you to know and recognize that it is the entity that is your client. Again, that may sound like a no-brainer, but as we're going to see, it's important for not only you to recognize that, but it's important for you to convey that message to all those other constituents so that they don't think that they themselves are also the client. Now, comments 1 and 2 to Rule 1.13 sort of expand on this idea that, look, you cannot get your instructions from this inanimate object of this organizational client, but for the constituents that you deal with, the officers, directors, and employees, et cetera. And as part of those discussions, the discussions that they have with you are protected by Rule 1.6, which we'll talk about in a little bit, which is about your duty to maintain the confidentiality of information relating to the representation of the client. But again, just because you represent the organization and you're having to deal with the constituents does not mean that those constituents are necessarily your client. That is the general rule, but it's also something that you must be careful to maintain and make sure that the client constituents themselves understand that. Because it's important that those constituents don't misunderstand that if you're in a discussion with these constituents and they have a misunderstanding of who you represent, the onus is on you to correct that misunderstanding. We find a similar message to Rule 1.13F in Rule 4.3, which deals with your duties and communicating with an unrepresented person, where if there's a misunderstanding of what you're there to discuss or who your client is, you must take reasonable efforts to correct that misunderstanding. And with Rule 4.3, if you find that the unrepresented person their interests are adverse to that of your organizational client, you may not give them legal advice. And depending on the jurisdiction, you may not give them legal advice except to advise them to seek counsel, or you may not give them legal advice, but you may suggest that they obtain counsel. But in any event, you need to make sure that they understand that you are not representing them. Now, why that is important is this. To create an attorney-client relationship, you don't need an engagement letter. All that is really necessary for there to be an attorney-client relationship is essentially a client or a prospective client who is providing confidential information to you with the view of you providing legal advice, and either you do make that person think that you are representing them, or you don't you stay silent, and you make them think that you are going to provide them legal advice. This particular definition comes from the statement of the law governing lawyers, but all this, what this is saying, can basically be boiled down in my mind to this. Does the would-be client, does the would-be individual client have the subjective, reasonable belief that you are going to provide them legal advice? That's a two-part test. Number one, that person has to have a subjective belief that, yes, indeed, you are going to provide them legal advice. And secondly, that subjective belief must be reasonable. And certainly if you are there telling them that I am not your attorney, it is going to be difficult for them, their subjective belief to be a reasonable one. But you do need to be prepared when you're dealing with these constituents. And I put up here on this slide what I'm calling the Upjohn warnings. And this largely comes from the Upjohn Corporation versus United States Supreme Court decision that's really talking about attorney-client privilege. But I think some of the same core ideas apply to this notion of making sure that the constituents don't think that you represent them as well. Where number one, you're reminding the constituent that your client is the entity and not the individual constituents. Number two, telling the constituent that anything that the constituent tells you is likely covered by privilege, but it's the entity's privilege, not the individual's. And it is the entity that has the sole discretion on whether or not to waive the privilege. And finally, this notion that the individual may wish to retain other counsel for him or herself if that person is concerned about their own possible exposure. Again, what that is doing is reminding the client that you are the entity's attorney and not the individual's attorney. And what you can do, because I know, for example, in my capacity as in-house counsel, I'll sometimes have colleagues say, well, you're my attorney. And I have to be prepared and promptly respond, no, I'm not your attorney. I represent the firm. And that is something that on a consistent basis you have to continue to reiterate with your colleagues. I have read some commenters suggest that maybe in-house counsel should go even so far as to draft an engagement letter that would go to the company management, which says, I represent the company, not any particular constituents. I personally think that that's impractical, but it's certainly something that you can do. I think it's more important on a consistent basis for you to be prepared and be consistent with the message. Whenever you hear someone say that you know, you're my lawyer, to be firm and say, no, I represent the entity. Please understand that. And again, as an in-house counsel, you guys are in a difficult spot because you need to not appear standoffish. You're going to need folks to communicate with you so that you can provide legal advice to the entity. But you do want to maintain this notion that, look, I represent the entity. I do not represent you. And one of the reasons is you want to avoid the situation in which there might be a joint representation. Because, okay, first of all, if you're dealing with a constituent on a matter and the constituent, again, has this subjective reasonable belief that you are representing them, that individual may well be a client of yours in addition to the entity being a client. And so whenever you're dealing with a joint representation, as Rule 1.13G recognizes, is possible, you're going to have to comply with all of the requirements under Rule 1.7 for having a joint representation. And those requirements are like any joint representation where you're representing more than one client in the same matter, that the clients are going to have to agree up front that there's not going to be any confidentiality as between or among the jointly represented clients. You as the attorney are still going to try to protect the confidentiality of the information to the outside world, but as to the group that you're representing in the matter, there's not going to be any confidentiality. There's not going to be any secrets. Likewise, there's not going to be any attorney-client privilege as between the group. Again, you're going to still try to protect the privilege from the outside world, but within the group, there's not going to be any privilege being able to be asserted one group versus the other. Finally, and this is very important, you're not going to be able to throw one client under the bus. You're not going to be able to take better care of or look out for more or not provide or provide legal advice or representation for that client adverse to the other client you're representing in the same matter. You're not going to be able to take sides. And that could be particularly difficult if you've got a situation where the interest of the individual and the interest of the entity are not aligned. The other thing, too, about situations in which you don't even have a joint representation, but maybe you've got a situation where people in the office know you're a lawyer. They come down to you in your office, knock on the door in a non-COVID environment, and say, I know you're a lawyer. I've got this problem. Can you help me out? Now, if you provide legal advice or allow that individual to think that you are representing them, that is an attorney-client relationship. One aspect of Rule 1.7 that a lot of people don't recognize is that current client conflict rule says that you can't represent one client directly adverse to another current client that you represent in anything. The relatedness of the two matters are immaterial. So if your client is the entity, but yet some individual within the entity comes to you and you're providing legal advice on something else, and now the company is asking you to take action against that employee, you've got a conflict of interest. And under the imputation rules, it's quite possible that the entire legal department would be disqualified from providing legal advice to the entity against that individual client. So it's, again, really something that you have to keep in the forefront of your mind when dealing with constituents, to not let them think that you are representing them individually. Another aspect of Rule 1.13 that I think in-house counsel need to hear about, and we won't go into great detail, but it's this concept of up the ladder reporting and reporting out. The situation is this: with Rule 1.13b, if as a result of your representation of the organization, you learn that an officer, a director, employee, etc., is refusing to act or is acting in such a way that it is a violation of law or it is a violation of an obligation of the entity, and that is going to be imputed to the organization, is likely to result in substantial injury to the organization, you may have a duty to report the violation up to a higher authority. You're going to look certainly at the seriousness of the violation, the consequences of the violation, the responsibilities of the person who is acting or refusing to act, and the motivations of that person. And it may well be that the entire situation can be resolved by you communicating with that person and saying, hey, look, this is what I'm seeing going on. This could really affect the company. I think that you should do something else. I think that you should not act in this way. I think you should stop, et cetera. Again, if you think it's in the best interest of the company, you probably have an obligation to report that to a higher authority within the entity. And in fact, it may be that you have to report that to the highest authority. Rule 1.13c says, if you've reported that to the highest authority and they haven't timely addressed it, and you are still concerned that it's not in the best interest of the entity, it's a clear violation of law, and it is reasonably certain to result in substantial injury to the entity, you may disclose to the outside world just enough to remedy the situation. I think that 1.13b and c are this recognition that your client is the entity, so the duty of loyalty rests with the entity. But this is something, when you find yourself in these situations, you do have to be very careful. And I would advise, if you're ever in this situation where you're needing to contemplate reporting to a higher authority, or certainly the highest authority, and by all means reporting out, that you may want to seek your own independent legal advice from outside counsel, but not counsel for the entity. the other thing to recognize too with 1.13C, that is a relatively within the last decade or so change to the ABA model rule. But before the modern version of 1.13C, there was no reporting out option. If it got to that level, your opportunity, your only out as an in-house counsel was to withdraw from the representation. You had to keep quiet and resign. So at least the ABA has recognized that this type of situation can be very distressing for in-house counsel. Finally, ABA Model Rule 1.13D simply says, look, if you can't rely upon 1.13C to report out if the reason why you know the facts that lead to your conclusion that it is a clear violation of law is that you have been specifically asked to provide legal advice on the violation itself. So that makes sense. If you're being asked to look into something and your role as counsel, you shouldn't then be able to turn around and disclose to the outside world what you find is a clear violation of the law. Our next topic is the attorney-client privilege in the in-house counsel context. Now, as in-house counsel, you probably have a greater grasp of what your organization does in its various departments, in its various aspects, than possibly anybody else. You know people in the IT department. You know people in accounting. You know people in human resources. You know the business people. You've got your hands on a lot of different groups. You're also very smart, and you're very wise. As this slide recognizes, you are the trusted advisor to your client. And people also know you're a lawyer. And people have seen television shows and movies and heard of this concept of the attorney-client privilege. So all that makes it very difficult for you because on the one hand, you are providing business advice, and on the other hand, you're providing legal advice. And sometimes it's difficult to identify the differences of the two. So the other thing that's difficult is people, as I suggested, don't have a great grasp of what the attorney-client privilege is. And at its bare minimum, whether it's in statutes, whether it's in rules of evidence, whether it's founded in common law, the idea is that communications to you as a lawyer from someone seeking legal advice is privileged, meaning it can't be discovered. It's a very ancient doctrine. It dates back to Elizabethan times. And because it's so powerful, because it's so impenetrable, and because it goes against the notion of discovering any material facts related to a dispute, not only do you as the party asserting the privilege have the burden of establishing all the elements of the privilege, courts hate the privilege, and they will look at it with very, very refined eyes and put great amount of scrutiny on the assertion of privilege. This next slide is the basic Kentucky evidence rule for privilege, and again, it talks about the same things that I was just mentioning about confidential communications for the purpose of rendering professional legal advice. And the rule itself sort of identifies all the folks who would fit into what I'll call the privileged group, whether that's representatives of the clients, representatives of the lawyers, etc. But again, at its most basic, privilege is only confidential communications made for the purpose of facilitating the rendition of professional legal services to the client. Now, again, from a business advice versus legal advice standpoint, courts are going to have a difficult time identifying what is business advice and what is legal advice. And these are some of the factors that a court is going to look at. Number one, what was the prominent or primary purpose of the communication? Was it legal advice? Was it business advice? And can the court determine, based on the language of the communication itself, as to whether the intent was business advice or legal advice? Number two, was the legal advice so intricately intertwined with the business advice that you can't tell the difference? Now, if that's the case, chances are that it's probably going to be considered legal advice, but again, it's not always clear. Finally, could the advice be given by a non-lawyer? If it could be given by a non-lawyer, chances are then it's probably not going to be considered legal advice. Something to think about. Now, in terms of trying to identify what is or isn't privileged, the Eastern District of Pennsylvania actually, a court there gave us a gift. A couple years ago in a case dealing with a breach of contract action, the court was having to review in camera a number of documents that one side or the other was claiming was privileged because in-house counsel was involved. The particular judge in this decision sat down and provided essentially some examples of what would and wouldn't be privileged. Now, before, when I was saying that for these quote-unquote live presentations, we have to do some different things. One of the things that some of the jurisdictions require us to do is some interactive stuff. And so what I have done is I have found, I've pulled some of the examples that the court in the Sodexo case out of the Eastern District of Pennsylvania used. And so what I'm going to do is I'm going to put up each of these questions on a poll for you to be able to respond whether you think the document or the communication is privileged, whether you think it is not privileged, whether it depends in your mind, or whether you simply want to punt to the next one. So let's start with the first one, assuming that I can work the technology. Okay, the first one is up on your screen, and we will go and open the first poll. I'll go ahead and close the poll. So with the first question, the president of a food service company or corporation sends an email to general counsel. What are the requirements of a binding contract? That is a fairly easy one. That is privileged. It is the president of the organization seeking legal advice from the in-house counsel. The majority of folks agreed that it was, 24 out of 48 agreed that it was privileged. Okay. Our next question. Ladies and gentlemen, I'm having technical difficulties pulling up the poll, so I'll let you take a look at the question, and I will simply tell you what the answer is. I'll give some time for folks to take a look at it. President, the corporation's vice president, who as part of her job is engaged in negotiations. Our general counsel has advised me that in order to form a binding contract, we need 1, 2, and 3. That is also privileged. Next, sales manager to vice president. I've met with the manager and we have a handshake deal. How much detail do we need in the written contract? That is not privileged because there is no rendering of legal advice here. Next, the general counsel to in-house paralegal. President wants a contract with items 1 through 6. Please take the language from our prior contract with College Z to get the process started. That is privileged because they are asking for legal advice, or legal services rather. Next one. Vice President to paralegal. I heard you were working on our contract with College X. Please write these exact words into provision 6. It is hereby agreed that the amount is $400. That is not privileged, and it's not privileged because the paralegal in that sense is only acting as a scrivener. So there's no real legal advice being provided there, so it is not privileged. Next, general counsel to the vice president. Here's my proposed contract attached to this email. Show this to College X, but tell them it is not non-negotiable. This one really depends. The document, the contract itself is not privileged. The email discussion between general counsel and vice president is privileged, assuming it's not shared with the other side. Next, as a result of a dispute on contract interpretation between the parties, VP discusses this with president and then contacts the general counsel about her interpretations of the contract. VP then forwards the email to College X. Well, it was privileged until the VP forwarded that email to the other side. At that point, it lost its confidential status and therefore is no longer privileged. So that was, again, a series of hopefully helpful examples that the court in Pennsylvania provided us that gives us an idea of how a court would view some particular emails and such involving in-house counsel from a privilege standpoint. Now, the work product doctrine, just a quick aside there, that is, of course, different than privilege. It relates to documents and tangible things only. It really, and this is important for folks to remember, the work product doctrine is only applicable in anticipation of litigation. If litigation is not anticipated, there is no work product protection. There may still be privilege protections, but there is not work product protections because, you know, that is in essence what the doctrine says, that we're looking to protect the attorney's work product, but only in anticipation of litigation. Furthermore, work product protection is not absolute. If the other side can establish a substantial need and an inability to get the information elsewhere, a court is likely to say that the work product doctrine does not apply. That, again, is different than privilege. If privilege applies, there is nothing that the other side can do to get through that barrier, that privilege barrier. So some of the things that you can do as in-house counsel to help educate your colleagues is first, look at this idea of the notice that can and should often be put on emails. That something, this email contains attorney-client privilege communications. Number one, it would be better to have such a notice on emails than not, but it's even better to have a more intensive or intentional placement of privileged communication notices on only those communications that you or your constituents really believe are privileged. If you put that on everything, it loses the effect. And in particular with Kentucky, and in this regard, I'm talking about the duties of the unintended recipient of a misdirected email. The ABA model rule says that the only duty of the unintended recipient of a misdirected email is to notify the sender that he or she has received that email. Kentucky has maintained the old rule, which is if you are the unintended recipient, once you realize that email was not meant for you, you were to stop reading, notify the sender, and abide by the sender's instructions. Now, because I know that, what I tend to do, and also to make my notification of attorney-client privilege communications intentional, I put at the very top of any email that I'm sending in my capacity as general counsel to the firm, AC privilege at the top. Because if you have the notice at the bottom, by the time the unintended recipient has read that email all the way through, the bell is already rung. You can't unring the bell. At least if you have AC privilege at the top or something of that sort, it might be bells and whistles to the unintended recipient that this was not meant for them. Number two, communicating with your colleagues about the reply all button. There are technological things that your company can do to prevent the rapid reply all button use. I know with our firm, we've got a button that comes up that says, do you really mean to reply all? That could be very important from a preventing of mass communication of an email that really doesn't need to be reply all. Counseling your colleagues about forwarding emails that contain your privileged communications. Again, once that email gets outside of the privileged team, outside of your organization, that document, that communication is no longer going to be privileged. Also, carbon copying you as the attorney. Just because you're carbon copied on an email does not make it privileged. Again, the core question is going to be whether or not that communication was for the facilitation of legal advice, or whether it's you providing legal advice. In that regard too, again, communicating and educating your colleagues that, number one, separate out documents, communications that are business advice and legal advice. And if they are seeking legal advice from you in an email, have them be trained to start off an email by saying, I am writing to such and such in his or her capacity as general counsel for the entity so that I can obtain legal advice from them on this issue. That is going to go a long way to establishing that the communication was for the rendition of legal advice or services. Another topic that often comes up in my dialogues with in-house counsel is Rule 4.2, the no contact rule. And this is the rule that basically says if in representing a client, if someone else is represented by counsel, you can't communicate directly with that person as a lawyer in the matter unless you have the other lawyer's consent or you're authorized to do so by law or by a court order. The rationale behind the no contact rule is basically you don't want opposing sides to be duped into making admissions, making commitments, doing anything to really jeopardize the attorney-client relationship of the other side when the other side has taken the step to actually retain counsel. Now, from an in-house counsel standpoint, some things that you need to keep in mind is there is, for example, an ABA ethics opinion that says that you as an in-house counsel for an opposing side, the other lawyer can communicate directly with you because you're a lawyer, and it's unlikely that you are going to be duped into admissions, et cetera, unless your entity's own lawyer says to the communicating lawyer, hey, that's my client, don't communicate. So you do want to be on your guard. Another aspect of Rule 4.2, at least in Kentucky, is there is an ethics opinion that says if the other side emails you, CCs his or her client, you cannot do a reply-all response to that email that includes that other attorney's client without violating 4.2 unless you have the other attorney's consent to do so. That seems a little extreme, but at least that's what the ethics opinion says. That can be particularly frustrating, I know, for transactional lawyers. And I think what's important there is for you in-house counsel, in both your dealings with your non-lawyer constituents and with your own outside counsel, is have a dialogue with them and see whether it makes sense to reach out to the other side and see if there can be some understanding as to whether or not you and they can communicate directly with one another. If there is that consent, then you can very easily communicate with the other side without violating 4.2. It just means that also you and your colleague constituents have to be careful about what is shared and what is not. And so I think that there needs to be that understanding as well. Finally, at least with 4.2, one of the things that the rule addresses, or the comment to the rule is, you know, when you're dealing with the entity as the client that is represented, there are only certain constituents that are covered by 4.2's no contact rule. And those are the types of people who are constituents who supervise, direct, or consult with the lawyer, have authority to obligate the organization, et cetera. It's not going to apply, the no contact rule is not going to apply to your run-of-the-mill employees. Importantly, too, it's not going to apply to former employees. And so what entities, organizations should consider doing is having confidentiality agreements in place with the former employees before they leave the employment to maintain the confidentiality of information, et cetera. Because once they are no longer employed, those former employees are not covered by Rule 4.2. Our last topic today is going to be Rule 1.6 about the confidentiality, of information relating to the representation of a client. Now, typically, this type of discussion is going to be more geared towards outside counsel, but nonetheless, you know, there are things that you as in-house counsel need to be mindful of. We're going to talk about some of the technology aspects of rule changes. You yourself have an ethical obligation to make sure that non-lawyers that are working with you as part of your representation, that their actions are commensurate with their own obligations as if the ethical rules apply to them. You're taking reasonable steps to make sure that their conduct is commensurate with those obligations. The other thing is, I think that it's important for you as outside or in-house counsel to recognize that outside counsel, particularly when you're dealing with more sensitive information, you and they should be having a dialogue as to what types of security measures should be put in place to maintain the confidentiality of information relating to the representation of the client. So let's start with the rule itself. Rule 1.6a is a lot broader than nearly all lawyers recognize. It's not just secrets, it's not just privileged information. The rule requires us to maintain the confidentiality of really any information relating to the representation of the client, unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. Now, paragraph B has depending on your jurisdiction, has an enumerative list of anywhere from 4 to 7 narrow exceptions that would allow you to disclose information relating to the representation to fit within one of those categories, but only as much information as is necessary to satisfy that. And so, for example, complying with a court order is one of those exceptions. Preventing likely substantial injury or death is another one of those examples. So really, they're very limited, and in fact, there isn't, for example, even a publicly available information exception to Rule 1.6. Now, one thing that the ABA did is, as part of some technology amendments, I'll call them, is they added this Rule 1.6c, that the lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. Now, I personally don't think that this is something that is anything new. I think that under Rule 1.6a, one already had that obligation, but I do think it's important that the ABA thought it important enough to actually make this a rule to bring to everyone's attention that it really is the attorney's ethical obligation to take reasonable efforts to prevent either bad actors getting to your documents or people inside inadvertently sending information. As I mentioned, these are part of some of the technology amendments that the ABA did all about the same time. Probably the two most important is this Rule 1.6c and the comment about reasonable efforts, and we'll get to that in a second. But even competency, Rule 1.1, where it says part of competency is the lawyer understanding and recognizing the risks and benefits that particular technologies provide in assisting the attorney in providing legal services. That is part of competency now under the ABA model rules. Some of the reasonable efforts that an attorney should take into account, some of the factors in deciding what's reasonable, are set out in this comment 18 to Rule 1.6. First is the sensitivity of the information. You know, if it's run-of-the-mill information, you probably don't need to take a great deal of measures to protect it. If it's trade secret stuff, you're going to need to ramp up your protections. The likelihood of disclosure if additional measures are not employed. To me, items 3, 4, and 5 sort of go into the same bucket. Essentially being, how difficult is it going to be for me to continue to provide valuable legal services to the client if the security measures are so intense that I can't effectively represent you? And there is where I think the communication between the client on the one hand and the attorney on the other is important, because there you're getting at, you know, how much effort do we want to put into securing these documents? Do we want to use encryption? Do we want to segregate and limit access to who within the firm and who within the company has access to these documents, et cetera? It's that type of dialogue that I think is important for the client and the attorney to have. The changes in the rules were followed by a series of technology ethics opinions, if you will. I've got them listed here. The most important of the three is probably ABA Formal Opinion 477R, and that is dealing with your obligation on the front end to secure communications of protected client information. And there, what's interesting about that is the opinion starts out recognizing that in 1999, the ABA said you didn't violate the rules of professional conduct if you communicated with a client through unencrypted email, because through unencrypted email, you've got an expectation of privacy, not unlike faxes, letters, etc. Spring forward to 2017, and the ABA says, whoa, things have definitely changed since 1999, and it's no longer a question of if you might be hacked. For law firms, it's really a question of when. And so because it's more of a question of when and the proliferation of devices and the number of hackers that are out there, et cetera, we're going to ramp up the obligations of attorneys to really take a look at implementing safeguards to protect client information. And again, it goes hand in glove with the amendment to Rule 1.6 to add Rule 1.6c. One of the things that the lessons that the opinion sets out is these 7 here, and some of the ones that I'd like to address briefly as we're running up against time is, for example, number 3, understanding and using reasonable electronic security measures. And what that is getting at is, do you have secured outside internet access? Are you using a VPN? Are you using Citrix? Are you using two-factor authentication? What kind of password setups do you have? Do you have your passwords change every 4 weeks, 6 weeks, et cetera? And do you establish firewalls? It's those types of things that attorneys need to be thinking of. And again, even from an in-house counsel standpoint, are you taking steps to communicate with your IT department to see whether they are up to speed on your own internet safeguards? Number 4, determining how electronic communications about a client's matter should be protected. Again, are you going to use encryption or not? That's a conversation that you as the in-house counsel and outside counsel should probably have. Number 6, training lawyers and non-lawyers. One that I've used there, I know, for example, that hackers and scammers really love the holidays. And so what I will do is routinely send around reminders to the firm saying, be on the lookout for scammers. Here's how the scams work. Here's the types of scams to keep an eye out for. So that, again, my colleagues are sensitized to that. I'm working on educating them. And finally, due diligence on the vendors with respect to technology. In that regard, do you know where your data is being stored? If you're storing in the cloud or if you're storing off-site, are you storing in a foreign jurisdiction that may not have the type of property protections that we have in the United States? Maybe your data is being stored in a foreign jurisdiction where the state, being the government, has the right to come in and access and use any information within its borders. Again, you need to educate yourself about that, and your outside counsel need to be up to speed as well. That's all the time that we have for this presentation. Again, my focus was sensitizing y'all to some of these issues, making sure that you are comfortable enough in really educating your colleagues, your non-lawyer colleagues, about some things, sort of such as the attorney-client privilege, et cetera, and really encouraging you to communicate not only with your non-lawyer colleagues within your organizations, but also communicating with your outside counsel. You should expect your outside counsel, particularly with sensitive information issues, that you and she or you and he would have a dialogue so that both sides have an understanding of of what information should be protected and how much it should be protected. I thank you very much for your attendance today. I see that some comments have come in, and we will address those after the recording has concluded. Again, I would remind you that if you have not done so, to send a private message to Renee Lamb that will identify you by name, first and last, by what state you're barred in, and your bar license number for that jurisdiction. That's how we're keeping attendance, and we need that so that you can get the all-important ethics credit. Again, the next CLE presentation will be on February 24th. It'll be Amelia Adams from our office here in Lexington, and she will be addressing anatomy of a bankruptcy case, practical considerations for your in-house client. Again, I want to thank you for attending today. I hope that you have found this helpful, and I hope that you and yours are all staying safe and healthy during this COVID pandemic. Thank you.